Order in court, all rise. Please be seated.
Morning. Have any matters before the jury comes in?
Your Honor, Mr. Savage,
All right. Havish before the jury comes in.
From the state.
Please, the court.
Yes, sir.
Your Honor, this morning we received a motion from the prosecutor in support of the admissibility of Peterson's contemporaneous notes in the interview of Michael Slager. We would like to address that at the time that the court feels it's going to come into evidence. So I don't know whether the court would prefer to do that while the jury is out. And the state has also advised us that they're going to call an employee of Mr. Slager's previous attorney, and which I was satisfied.
All right. Yes, sir.
Thank you, Your Honor. If I may, I'd like to address the second part. Our next witness is Levi Miles. He is employed in April 2015 as he is presently as an investigator for attorney David Ayler. Mr. Ayler was retained as Mr. Slager's attorney initially upon this incident. As you've heard already, Your Honor, through several sources, but most directly from Lieutenant Gent from SLED. SLED conducted an interview of the defendant, Michael Slager. That interview took place in the presence of SLED Agent Peterson, SLED Lieutenant Gent, Mr. Ayler, and his investigator, Levi Miles. We are seeking to elicit testimony relating only to the statement given by Mr. Slager in the presence of SLED agents. I assume that the objection the defense has is one of privilege. Without going through privilege law in too much detail, one of the fundamental elements of a privileged conversation is obviously a conversation one intended to be private between just himself and his representation. This conversation was obviously an interview which took place in the presence of several people, including agents of the government. So we believe that privilege will not apply. I plan on instructing the witness, obviously, that our questions are limited to just that conversation that was non-privileged. And if the court wishes to instruct that witness to that fact as well, obviously that would be appropriate, Your Honor. Thank you. And I have a filing to that effect because it's a responsive filing. We never filed it, but if you'd like to provide a copy of that, Your Honor.
What was your purpose in preparing it?
We just anticipated that might be something that the defense raises, so we wanted to be prepared, Your Honor. It just cites cases on the basic.
So you have it for your own personal notes, or?
I had it as a response if the defendants ever filed anything, and also as my own personal notes. Yes, sir. But it's, I think as far as privilege laws go, this goes to really an elemental
As far as
aspect of privilege law that
privilege law?
the law of attorney-client privilege, Your Honor. The conversation must have intended by the client to have been private between himself and his attorney, and certainly not one that takes place in the presence of government agents, Your Honor.
And that's what you've just stated is based on what authority? Something that's written in your memo? Or?
Oh, no. It's hard to even find a case on privilege that doesn't at some point lay out the elements of privilege, and obviously establishing that privilege is the burden of the defense. The basic privilege elements of privilege, attorney-client privilege, is the communication made between privileged persons only, that being the client and the attorney or member of the attorney staff. Made in confidence, in other words, intended to be private, intended to just be for the attorney, and made for the purposes of seeking, obtaining, or providing legal assistance to the client. Obviously, we think the assertion of attorney-client privilege here fails because clearly a conversation that takes place with government agents present isn't intended to be a private one between a client and an attorney. The authority would be the restatement of law governing lawyers, U.S. v. Mayha, 655 F. 3rd, 126. That's the Second Circuit. U.S. v. Robinson, the 5th Circuit, 197, 121 F. 3rd, 971. And really, Judge, any case you find on privilege in South Carolina law, the State v. Love, 275 SC at 59, lays this out.
Response?
Please, the court. Your Honor, our objection is not limited attorney-client privilege. Would ask the court to take note of Rule 407, 3.8B2, in which rules of professional responsibility preclude a prosecutor from presenting evidence in a criminal proceeding. The evidence sought is essential to the successful completion of an ongoing investigation and prosecution, and that there's no feasible alternative to obtain that information. Well, with that as a basic fundamental principle, joining that with rules of evidence 403, as the prosecutor said, this information has come to the attention of the court and the jury through several other sources, including Lieutenant Ginn. That information, therefore, would be cumulative under 403. It also could be considered under 410.4 part of a plea discussion, as there would be no other reason for the attorney representing the accused to meet with investigators in terms of establishing the facts in which to engage in a plea or in a outright dismissal of the intended charges. So our objection is multifaceted. It's under 40738B2. It's under 410 Section 4. It's under Section 403, rules of evidence. It's also, to the extent necessary, under 501.
Would you read for me the provision of Rule 407 you're referring to?
It's on page 115 of 2016, volume 1, State South Carolina Rules of Court, Rule 407, professional conduct, Rule 3.8, special responsibilities of the prosecutor. He says, not subpoena a lawyer in the grand jury or other criminal proceeding to present evidence about a past or present client unless the prosecutor reasonably believes, and I go to Section 2. The evidence sought is essential to the successful completion of an ongoing investigation or prosecution, and 3, that there is no other feasible alternative to obtain the information. I realize that Mr. Levi Miles is not an attorney, but he is an agent of the attorney. We believe that this would incorporate both the attorney and his agents.
So you've mentioned three things, Rule 3.8, cumulative more prejudicial than probative. Were those the three things you mentioned, Mr. Savage?
Yes, Your Honor. 403 would provide cumulative information, and in the argument of counsel for the government, he said that the court and jury has already received this information from several sources, and then specifically mentioned Lieutenant Yen. So under 403, we would object as it's cumulative, and then judge under 410, inadmissibility of plea discussions and related statements. 410, subparagraph 4, any statement made in the course of plea discussions with an attorney for the prosecution authority which did not result in a plea of guilty or which resulted in a plea of guilty later withdrawn. We would say the purpose of the meeting with the agents that were prosecuted that morning was for the purpose of clarifying facts to enable either a dismissal of the potential charges, non-charges, or mitigation.
By the state?
Thank you, Your Honor. Starting with Mr. Savage's last assertion that these were plea discussions. As Your Honor has heard, these discussions took place before any formal charges had even been made. I think the assertion that this was a kind of plea discussion that is protected in the Rule 410 is I don't think you'll find anywhere that that's ever, that giving a statement to the police during the investigative stage has ever been interpreted to be plea discussions between attorneys for the government and the defense.
That's the weaker of his arguments. Move to
Sure.
the others.
As to the ethical rules 3.8, as noted by the defense, that rule is limited to an actual lawyer. And I would note that us calling of Levi Miles is done specifically to avoid running afoul of 3.8, which is the calling of the actual attorney at that time. I point Your Honor to section 3.8E1, which essentially says that obviously you don't run afoul of this rule if the information sought is not protected from disclosure by any applicable privilege. And as we've already discussed, this is not protected by the applicable privilege, being the attorney-client privilege in this case. I don't think certainly we're running afoul of Rule 3.8 in this case in calling the investigator for the attorney, as 3.8 is clearly just limited to the attorney. Furthermore, it also allows us on separate, distinct grounds, I believe, to call if this is essential information. Now, this goes also to the cumulative argument of the defense. This is essential information, which is, while we've had testimony regarding this discussion from Lieutenant Yen, Levi Miles played sort of a crucial role in this discussion in that he was used as the actor, if you will, directed by the defendant, Michael Slager, to act out the emotions of the victim, Walter Scott, during this time. This makes his recounting of this interview more probative than Lieutenant Yent's and more probative than Angela Peterson's on a whole different ground, and that he was actually moved and manipulated to act out the emotions of the victim. Furthermore, to his credit, Mr. Savage it focuses a huge part of his defense in discrediting the witnesses from SLIP. And when you come at Lieutenant Yent and Angela Peterson and discredit them, obviously it is the right of the state to present the same source of information from a different source, not containing the bias, the assertions of bias that Mr. Savage has made against all the investigative team in this case, including most specifically Lieutenant Yent and Angela Peterson. We're allowed to rebut that assertion of bias by asserting a source for the same information that does not carry that bias, and that's what we're attempting to do to Mr. Miles. I believe that covered each of the arguments of the defense, but we believe, having not run afoul of 3.8, 403, 410, or well-established elemental aspects of the attorney-client privilege, that this is proper testimony, Your Honor, but we will certainly be limiting it to just the interview taking place in the presence of staff.
It seems to me as if you have two questions presented primarily. One is if one is entitled to attorney-client privilege, then how is that, how do you lose that privilege? And typically you lose it if it's waived by the person who's entitled to assert the privilege. Then secondly, whether the attorney-client privilege extends to employees of the attorney. So you have here the lawyer whom you said you do not wish to call or not seeking to call because, I guess, of the attorney-client privileges. It would be very unusual to have a former lawyer in a trial testifying against a former client.
Unusual, yes. Unlawful, no.
Well, that's the question before me, whether or not it's proper, not whether or not it's lawful or illegal, but whether or not it's, as a matter of procedure, whether it's proper.
Right, Your Honor, and I think probably the most common way that the attorney-client is waived is by engaging in conversations with others present.
So if a client comes in a lawyer's office, if the secretary or paralegal or anyone other than the lawyer is present, then there's no attorney-client privilege?
I'm sorry, no. Let me concede. The attorney-client privilege certainly extends to staff of an attorney. That's not a point of law that we're disputing.
All right.
We're disputing that once I come to my client, I say, there are agents of the government. I mean, there's situations where having conversations in restaurants which are overheard waive the privilege. So certainly when you say, oh, there are agents from the government here, they'd like to speak with you, let's go speak with them, and would you like to speak with them, and that's agreed to, that is a knowing and voluntary waiver of the privilege.
Based on what authority? You said you had
Sure.
a memo for your own benefit, and you've some pretty weak insight in law to me on this point.
Sure, if I may I approach her? And I'm sorry, I have one copy. We can quickly get a copy to the defense if I can electronically approach.
Yes, sir. Anything else on this issue by state or the defense?
Your Honor, that we just were able to locate and send that file to the defense a few moments ago. More time with that. And my apologies to the court.
What do you intend to ask them?
Judge, again, I intend to just, after a few background questions, just to cover the interview that was given in the presence of the two SLED agents of the Congress.
And have him confirm what?
Have him mainly step down and reenact how the defendant had him act during this Slager's version of the events that took place. Also, there comes a time later that afternoon where they're shown the video that we've all seen in this case, and I intend to ask him if that video comported with what he was asked to reenact by the defendant earlier, just a few hours earlier that day, and some quick reactions to that. And essentially just covering on that given day the statement given to SLED agents by the defendant in his presence and in the government agent's presence, and in the later interview that afternoon where the video was being returned.
What are we saying? Seem to be the same thing. Anything else, Mr. Savage?
Judge, I just got the memo, but if this witness is allowed to testify, then I believe on cross we'll have to get into confidence. What the lawyer did prior to meeting with the client, what verification he did regarding the facts and circumstances of the case. I believe that the witness will say that there were never any notes taken, there was never a file open, there was never any visit to the incident site, there was never any research on the law, there was never anything done at all by this attorney or anybody on his staff. So then we have the whole issue of competence. Jury thinking that he was advised by a competent counsel, the lawyer who failed in all of his duties to provide competent advice to Mr. Slager. There was no effort at all on the part of that attorney to investigate the case, to learn anything about the case before he surrendered his claim to interrogation by the witnesses. Furthermore, this potential witness has a felony conviction for drugs within the past 10 years that have been best evaluated by the court to see if he should be appropriately cross-examined on that issue as well. It creates a lot of confusion for this jury in terms of perhaps collateral matters that otherwise wouldn't come before the jury if this witness testifies.
Who's your first witness today?
Mr. Miles is intended to be our first witness, Your Honor.
All right. Are we still waiting on jurors? All right. We'll take a recess. Let me think about this issue.